This courtroom session starts off routine, but don't let that fool you. Within minutes, we're going to see everything from courtroom humor to serious legal consequences that could change lives forever. One defendant faces years behind bars after a history of second chances, another walks a fine line between freedom and prison. And trust me, by the end of this hearing, you'll be asking yourself, did the judge get it right? Or was this too harsh? Let's break it all down.
All right. Vashawn, on Jose Perez and Megan, we're going to reset that. Norma, reset that for July 7th. Jesus Suarez Moreno. Everyone, you're not at the family reunion after a funeral, after a Black funeral. We are in court. So lower your voices. Megan, you know what I mean. Vashawn, you know what I mean. Every Black funeral becomes a family reunion. We're not doing that today, people.
Right away, you can see the judge setting the tone. This isn't just about procedure, it's about control. Courtrooms can easily become chaotic, especially with multiple defendants and attorneys, but maintaining order is critical. Notice how the judge uses humor about family reunions to lighten the mood, but immediately reinforces authority. That balance is key in court. Too relaxed, and things spiral. Too strict, and communication breaks down. What do you think? Does humor help in serious settings like this, or does it undermine the gravity of the situation?
All right. So he's scheduled for jury trial.
Correct.
All righty. You all are being recalled for Wednesday. We'll see if this trial concludes today.
Tomorrow morning?
Yes.
Thank you, Judge.
Norma, if he can have a reset for tomorrow. Isidro Sanchez. All right. Have you received all discovery?
I believe so.
Has an offer been tendered?
Yes.
Not.
How old are you?
What 33? Sorry.
33. Norma, I need a reset date in 3 weeks for plea deadline date. All right, May 5th.
May 5th. Thank you.
Yes, once you sign the reset form, you're excused.
Thank you.
Nicholas Gonzalez.
Morning, Your Honor.
Morning. All right, do you have all discovery?
So we don't, Your Honor. There seems to be some sort of glitch. We filed our notice of appearance. The notice of appearance shows up on the.
All right, so where are we on discovery?
We don't have any, and they've uploaded it, but we can't see it.
So I was gonna make a copy on a disk for him to pick up to review while we try to figure out why it's not transitioning.
All right, Ms. Ferguson, I need a 30-day make this a 45-day reset for discovery.
Here's a crucial legal moment that often gets overlooked: discovery issues. When the defense says they don't have access to evidence, that's a big deal. In criminal law, both sides must have access to all relevant materials to ensure a fair trial. That's why the judge grants a 45-day reset. Without proper discovery, any conviction could be challenged later. So this delay isn't a setback. It's actually protecting the defendant's rights. But let's be honest, delays like this can also drag cases out for months or even years.
All right, June 15th, and state at that time you need to be prepared to tender an offer.
Absolutely.
All right, thank you.
Thank you, Your Honor.
Thank you. Once you sign the reset form, you're excused.
Good morning, Mayor.
Morning.
For a moment.
How's it going?
I'm doing well. I'm in trial.
Oh,
I'm
okay.
226. I start up at 10:30. I got a motion here. The state's not objecting. It's not on docket, and I know the court has those issues. It's a motion to travel. We're requesting that if the
Do
court.
you have the motion?
Yes, I do. And if the court, on the order, the state just said that they're not opposing. It's the last page. He's leaving on the 23rd and coming back on the 27th. I'm
Okay.
requesting that the court, he's going to be giving his itinerary, which is attached to the motion to
Is he
pretrial.
on probation?
No, it's pretrial services. He's on bond. And that when he returns within 24 hours that he submit to a UA.
Now, this travel motion might seem minor, but it actually reveals something important about pretrial conditions. When someone is under supervision, even leaving town requires court approval. And notice the condition: drug testing within 24 hours of return. That's the court making sure freedom isn't abused. It's a constant balance between trust and accountability. If you were in that position, would you feel this is fair or too controlling?
Okay. Let me
My standard practice is always to request a UA within 24 hours and given an itinerary to
No.
either the court or to pretrial services, whoever is involved.
Okay, and just do a copy of that so you'll have it, and I'll put it in the system.
I appreciate you
All
most
right.
greatly. Be safe.
I love it. I'm loving the outfit.
I'm in trial and this is trial mode.
Hey.
It's trial mode. You got to look powerful.
Oh, yeah.
Thank
Well,
you,
good
Judge.
luck. Thank
I
you.
appreciate you.
You're welcome.
Thank you, ladies. You have a wonderful day. Be safe.
Veronica Callahan. All right, this is the PSI. Attorneys, when you approach the clerk, you need to let them know the reason for your approach, so they'll know what documents I need. All right, the court is calling 2025 CR 008-561, State versus Veronica Callahan. Can I have parties announced?
Lauren Espinoza for the state.
Matthew Allen for Miss Callahan.
And are you Miss Callahan?
Yes, ma'am.
All right. You entered a plea on January 27th. According to your plea, the state was proceeding on count 1, waiving the enhancements. Punishment is to be assessed at a cap of 6 years in the prison. There's a $1,200 fine. The state is opposed to your application. They're taking in consideration 2025 CR 014278. Have both parties had a chance to review the PSI and TAP evaluation?
Yes, Judge.
Yes, Your Honor.
Are there any objections?
None from the state, Your Honor.
No, Your Honor.
Any objections to the court reviewing the PSI and TAP evaluation?
No, Your Honor.
No, Judge, sorry.
Now we shift into a much more serious case, Veronica Callahan. This is where things escalate. The prosecution is laying out her criminal history, and it's not looking good. Prior offenses, failed probations, repeated chances, it all builds a narrative. In court, patterns matter. Judges don't just look at one incident. They look at behavior over time. And right now, the state is painting a picture of someone who hasn't learned from past mistakes. That's going to be very hard to overcome.
All right, and state you're opposed. Do you have any witnesses?
No, Your Honor, just briefly.
Defense, do you have any witnesses?
No, Your Honor. Just argument as well.
Right, just give me a moment. All right. State, you may proceed.
Your Honor, we ask that you deny Ms. Callahan's applications and sentence to a cap of 6 years in the prison. Ms. Callahan has criminal history. She's been convicted of 2 DWIs, a manufacture and delivery of a controlled substance, PG1, as well as the possession of a controlled substance, PG1, 4 to 200 grams, as well as another possession in 2016. Of these cases, she's been granted probation in 4 of these, 3 of which she was granted probation resulted in motions to revoke and sentencing either into the respective Bexar County Jail or TDC. Ms. Callahan has been given chances on these probations and ultimately cannot comport her behavior to comply with the rules and conditions laid out before her. Based on the PSI and TAP, Ms. Callahan's in the pre-contemplation stage. We can see here when she recounts the facts of this underlying case, she essentially blames the officer. She said that she drove away because he reached his hand inside of her vehicle without providing a reason for the stop. However, she was afforded that explanation that it was because of expired registration. It was only because of her action of not cooperating with turning over her ID and identifying herself that the officer attempted to open the door to assist her out of the vehicle for non-compliance. She then drove off, and it was only after her vehicle was spiked, the rear tires had blown out, and there were multiple patrol units following, both marked and unmarked, that Miss Callahan stopped. Once she stopped, she still did not comply. She refused to get out of the vehicle and had to be assisted out by officers. Your Honor, Miss Callahan alleges that she has ceased majority of her drug usage throughout her life. However, I think it's perplexing that she expects the court or asks the court to believe that she has no usage. She merely just possesses narcotics. So
This is where the prosecution sharpens its argument, and it's powerful. They're not just talking about past crimes, they're questioning her credibility. Claiming she possesses but doesn't use drugs? That raises eyebrows. In court, consistency is everything. If the judge senses denial or lack of accountability, it can completely destroy a defendant's chances at leniency. Do you believe her explanation, or does it sound like she's avoiding responsibility?
because of these reasons, Judge, we'd ask that you deny her applications and sentence to a cap of 6 years.
Yes, Your Honor. The criminal history is what it is. So she was on parole. She completed that. As far as the instant offense, it's not a drug case. It's an evading arrest case. Her recitation of the facts are just that. It's a recitation. It doesn't say, I'm not guilty of evading arrest because the officer reached into the vehicle. It's just her recounting what happened. Obviously, she's here because she's taking responsibility. She called the police even when she was driving, and we've had multiple conversations. One, you can't take off when a police officer is there. Two, if you did, when you call the police and there's multiple other officers there, you pull off to the side of the road. You don't get to choose where you stop. And she understands that. She understands that, takes responsibility. That's why she's here today. She's not saying I didn't evade arrest or that there was some legal reason why I was able to not comply with the officer's commands. And that's why she's here, because she took a plea to accept responsibility. Since she's been out now, as far as the PSI goes, it says here current address. She actually does now have a stable address here in San Antonio, Texas. So she's not homeless, which helps with obviously trying to.
Why didn't she pull over?
The reason she didn't pull over is because she didn't feel that the officer explained anything. She thought she just got pulled over, and then he was reaching his hands into the vehicle. She felt unsafe. That's why she left and called the police herself.
So why did they have to put spikes down?
Again, that's because she was then trying to say, well, she was going to feel safe if she went to her house. So she's not driving at a high rate of speed, but we've had that conversation before. And so something from probation would be like a cognitive course and thinking and critical decision making, because obviously that's an error in judgment. And that's a mistake. That's why she's here. As far as she does have a stable home, she actually has two jobs. One is a home health care worker, and I know the court sometimes does not allow people, but she has another job where she helps remodel a business for a man named James. She provided a letter from him to probation as well. So we have talked about this court and home health care working, and that's why she has another job set up and is already working that. Like I said, her housing, she actually had a trailer where she paid an individual $4,000 to live there. Well, that individual is not there any longer, and his wife is not agreeing with that. So she lost out on that money, but again, she's found other places. Mental health, she had been diagnosed a long time ago with manic depressant and bipolar. Again, she is working. She has support here. Paul Dickens is here in the courtroom, and he shows up. She showed up to court yesterday because she's heard this court say, do not show up late. She showed up a day early. She takes this case seriously. I don't see how sending her to prison sends any message or helps anybody. Again, she can take drug tests. She can work. She has housing. She can take a cognitive course. She can do a mental health evaluation. She even explained about that some of these things during the interview, she was crying because it was bringing up past things. And so she tried to be open and honest about it, about her past. And so again, they cognitive behavioral therapy, again, there's some adverse childhood experiences. She has had a pretty good childhood. I just think that the court can put conditions in place that allows Ms. Callahan to continue to.
Now the defense steps in with a completely different narrative. They're emphasizing rehabilitation, stable housing, jobs, mental health treatment, support systems. This is a classic strategy. Show the judge that the defendant isn't the same person anymore. Courts often prefer rehabilitation over punishment, but only if they believe change is real. The big question here is this genuine growth or just another promise?
Support herself, get better, and protect the community all at once. And so we're asking this court to give Ms. Callahan just an opportunity to go on probation. I understand she had been on probation a while back and didn't take advantage of that. But she is a different individual here today. She wants to take responsibility. She does want to show the court and herself and her support system that she can follow this court's orders.
May I answer the question
About
the reason of,
Do y'all need to step back?
well, the reason being was that it was.
Yeah, so she had conversations with the supervisor of SAPD about the interaction and some of the ways that were done. And so, but again, that's after the fact. That doesn't absolve her from it, but she has tried to take responsibility, examine herself and her responsibility in that situation. And obviously she was wrong, and that's why she's here today.
State?
Your Honor, I would just ask the court to deny applications. Ms. Callahan told, when asked how supervision would help her first statement was, it would definitely help me so I don't lose my freedom. I think that's what is exhibited here. Ms. Callahan thinks her freedom is more important than the law. She thinks that she can flee because she feels unsafe. And at what point are we to show Ms. Callahan that you must comport and comply, and you can't keep running from things because you think you're right? So I don't believe she would be a good applicant or candidate for any sort of probation judge. And while this court may and will probably be able to accommodate and target some of the issues Ms. Callahan experiences, I don't think she is deserving of that chance because she's shown she cannot comply.
All right. Anything you wish to say? I mean, if you want to say something, then I'll have to put you under oath. State will have a chance to ask questions.
I just know that.
All right, no.
No,
Do you want,
I don't want to.
Okay. No, Your Honor.
you're sure? Ms. Callahan, what I'm telling you, if there's something you want to say to me, then what I have to do is I have to swear you in. And then I will listen to whatever you want to say to me, but the state will have an opportunity to ask you questions as well. So do you need to speak with her concerning that, counsel?
No, Your Honor, we've spoken about it, and no, she doesn't wish to talk other than what I've explained, and what she said.
All right, Ms. Callahan, I reviewed the PSI, the TAP evaluation. I've listened to your attorney and listened to the state.
And here it is, the decision. The judge denies probation and sentences her to prison. This moment highlights something critical. Past behavior can outweigh present efforts. Even though the defense showed progress, the judge ultimately decided the risk was too high. It's a harsh reminder. Second chances aren't unlimited. At some point, the court draws a line. Do you think this was justice, or was this too severe given her efforts to improve?
I just don't think you're a good candidate for probation. Okay. I'm going to find you guilty, taking consideration 2025 CR 014278. There's a $1,200 fine, time and money run concurrent. I request the therapeutic community, and I'll sentence you to 3 years in the prison and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Right to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. All right, good luck to you. Justin Bettis. Oh,
My last name gets pronounced correct.
how is it Bettis? Thank you. I try. All right, on this case, where are we on discovery?
It does look the discovery's complete, Judge. I just want to, right?
Yes,
Yes,
okay.
yes, Judge. Sorry about that.
So, and does there need to be evaluation?
No, Judge, I think we have a plea agreement. I would like to see if we could request it recalled tomorrow. I am getting called over in civil district court for a hearing that what has been set for a few months now. So they're killing me. And I also need to verify that Haven for Hope will accept him back. And he's given me his case manager, and I can get that done today and be ready to go tomorrow if we can recall him for tomorrow.
All right, and do y'all think he will be appropriate for mental health court?
I don't think mental health is an issue, Judge. I do think the TAP eval as a part of probation will be good because I think he's struggled with alcohol. And this was directly related
All
to,
right, and on the civil side, who is your hearing with?
I'm sorry,
On the civil side, who's the judge?
it hasn't been assigned yet because Matt Saucy on the opposing counsel, he has marked us conferring and we're waiting to get assigned as soon as I can get over there.
Okay, well, if you all do the plea now, I'll take it up. That way we can get him where he needs to be as quickly as possible.
Okay, that would be fine.
All right, so.
I'll let him know. I'll let
yes.
my,
And I will take you all up as soon as you've
Okay.
done the plea. You can
Thank
skip
you.
in line.
okay, perfect.
Thank you.
Thank you.
All right, who's next? Billy Max Peacock. Billy Peacock.
He's not here.
All right, if you'll come forward. Deputy, if you can make an announcement for Billy Max Peacock III, please. Court is calling 2026 CR 0027445 State versus Billy Max Peacock III for the state defense.
Matt Stolhansky for Mr. Peacock.
All right, this hearing was scheduled at 9 a.m. It is now 9:51 a.m. The defendant has not answered the docket. Deputy, did you make an announcement?
Yes, Judge.
And what were the results?
He-
All right, defense, have you had any contact?
Not this week. I've spoke to him before, but his phone number's been disconnected and my alternate contact number is not working, so.
All right, state.
Now, this is a completely different situation, but equally serious. When a defendant doesn't show up to court, it's a huge red flag. The judge immediately issues a warrant with no bond. That means the next time he's found, he goes straight into custody. Missing court isn't just a mistake. It's seen as disrespecting the legal system. And consequences like this are swift. Would you risk missing court, knowing this could happen?
All right, the court will issue a judge's warrant, remand your client without bond.
Yes, ma'am.
Thank you.
There you go.
Yes.
Thank you.
Who's next?
Stephen Limon, page 5 down.
Stephen Lamone.
Yes, Your Honor.
All right, where are we on discovery?
Discovery looks sufficient, Judge, at this time. I know this is early on in the settings of the new case, but we wanted to see if the court would allow referral for felony drug court. This is an individual that has demonstrated some treatment needs, and we want to see about potential options so we can hopefully dispose of the case while also getting him treatment.
So are you all planning on entering a plea and then?
So he's on probation, Judge, for a DWI case.
Mhm.
He also has a newly indicted DWI case, which I believe we can see the concern for treatment, Judge. He was granted probation and set to meet with felony veteran treatment court. We called them earlier this week to see if there's any avenues that they would keep a spot open. They
Mhm.
said, unfortunately, at this time, they're at capacity. But he was let out of custody and he had to make an appointment with them. He missed that crucial appointment, and at which time after that, a warrant went out, Judge. So we're asking for one final referral of this court for possible felony drug court to see if Judge Glenn has some ideas for treatment options, which if it includes inpatient, my client is willing to undergo that as well.
What do you want to call over to felony drug court, or if you would like me to send them an email to see if they even have any openings?
Okay. Yes, Judge, that's not a problem. I
right.
can contact Ms. Zamarron.
All right, if you want to call and see if they even have any openings, because if they don't, then
Understood. Yes,
Okay.
yes, Judge. Can we
Yes.
heard on this matter once I've
Sure.
done that? Okay, you can take this.
All right, who's next?
Here's Jones, page 6.
You can come up to.
Pierce Jones.
Yes, yes. This is also mine.
Okay. Is this an MTR?
No, Judge, it's a regular case. It is older because of some competency issues. She was at the state hospital for a couple of years.
So then what I'll do is, since there were competency issues and he's currently competent,
He's currently competent, Judge, that's correct.
all right, I'm gonna do this for a quick turnaround for a jury trial and plea deadline date.
Of course, Judge, yes.
Yes. Do you have all discovery?
The discovery, Judge, there is a lot of it. I was talking with the state about that. This is a first setting since been thrown from the magistrate courts. I was just gonna request a short recess of 2-3 weeks.
Okay,
And I believe that there may be an affidavit that they're complaining with.
all right, Ms. Ferguson, I need a 3-week reset. All right, May 5th. All right, we'll be back on May 5th, okay?
Including mine.
And and counsel, if you can let me know, if there are any competency issues that arises so that we can make sure he gets where he needs to be.
Surely will, Your Honor.
All right, thank you.
Yes, thank you. Have an update for the court.
Yes,
May re-announce on Mr. Stephen Limon.
yes.
Okay, so Bashan spoke with Ms. Zamaron, very appreciative of that. She stated that they do have spots available if the court were to send a referral. Ms. Abrams also had the great idea of cap evaluation as probation does not have one on file for him.
Okay,
If the court saw suitable to order that, we would appreciate it, Judge.
all right. Bashan,
Yes, Judge.
when do you want this recalled for the, how long will it take for the tap evaluation?
3 weeks.
Okay,
Get it back sooner, I could let Norma know.
all right, so we'll recall it in 3 weeks and a referral to felony drug court.
And, okay, and I'll just do it under probation.
Yeah, because that'll be easy. Norma? Oh, I'm sorry. I need a 3-week reset. It's on Stephen Limon.
May we do May 5th, 3 weeks? That's the one my other case.
All right,
was.
Norma, can you put it for May 5th?
Awesome. Great,
Thank you.
appreciate that.
Sure. All right, the court is calling 2025 CR 014516 State versus Julian Teo Jr. Can I have parties announced?
Brandon Prada for the state.
Good morning, Judge. Alfonso Cabañas for the defendant, Julian Teo Jr.
And are you Ms. Teo, Mr. Teo?
Yes, ma'am. Yes, Your Honor.
All right. Counsel, you received all discovery. Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Teo, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented
We are, Judge.
on both counts?
Oh, I'm sorry, Judge. We'll be waiving count one, we'll be waiving count one, proceeding on count two.
Any objection?
No objection, Your Honor.
And counsel, is this an application for deferred adjudication as well or no?
No, just regular probation.
All right. Mr. Teo, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
In count two, you're charged with possession of a controlled substance, penalty group 1B, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea.
Here we see another defendant entering a plea, and this process is extremely important. The judge carefully ensures he understands his rights, the charges, and the consequences. This isn't just paperwork, it's a safeguard. Once a plea is entered, especially with a waived right to appeal, there's very little room to go back. Every "yes, Your Honor" carries serious weight. It's a moment where decisions become permanent.
Court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against
I
him?
believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Teo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 2. They're asking that your punishment be assessed at 5 years in the prison. There's a $1,000 fine probated, and they're recommending community supervision. Did you understand that to be your plea?
Yes, Your Honor.
State defense, is that the plea?
It is, Judge.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 100 hours community service restitution, the DOEP course, and MRT. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Judge will offer state exhibit number 1, including all attachments.
No objection to state 1 and attachments, Your Honor.
State, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consent stipulation of testimony and stipulations. Court will accept in evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Just ask the court to follow the plea agreement with the state, Your Honor.
All right, are you employed?
I was recently hired, Your Honor.
All right, what do you do?
I'm a remote customer service representative.
All right, do you have any children?
No, I don't.
And if you're drug tested today, what are the results going to be?
Negative, Your Honor.
When's the last time you used?
Probably June. I want to say almost a year ago. I've been on probation from a different offense out of Denton County. So I've been doing drug tests for that probation.
And what are you on probation for in Denton County?
It was for possession of controlled substance, THC, a prescription that I had out of Oklahoma.
And are you still on probation out of Denton County?
Yes.
All right, how long are you on probation there?
Until June of next year.
All right, and what are your conditions there?
I'm sorry?
Your conditions of probation there, because, and the reason why I'm asking is because if you have certain conditions there, I don't want to double it up here if he's already doing it there.
So I have 120 hours of community service that I'm working on. A TAP evaluation scheduled for June, and the DOEP offender cart, the drug course that I already completed last month.
Judge, and it's my understanding that even though it's in Denton County, he is reporting with a probation officer here in Bear.
Yes.
Okay. Do you have that cause number?
I do not, Judge.
Okay. Probation.
Yes, Judge.
Are you able to run concurrently whatever is happening with this case out of Denton County? The case is in Denton County, but I guess it's been transferred to Bear. Are you able to see what his conditions are?
If it was transferred over, Judge, we could request a copy of the petition from this officer over there. I don't know that we would have it in our system now. If you have the case number, Judge, I can look that up.
No, I don't have the case number, but his TAP evaluation is scheduled in Denton County, he says in June. So I wouldn't want us to do a second TAP if he's already scheduled for a TAP.
We can request results, judges, instant, should send an SR to you. And then I could
All right. So this is what the court is going to do. As previously stated, the court is finding the defendant guilty of count 2. There's to be regular reporting by Zoom or in person. Regular random UAs or the patch. $1,000 fine that will be probated. I'll notate that he has a probation case out of Denton County that's been transferred to Bear. He's informed me with the Denton County case, he's already, as a condition, he already has 120 hours community service restitution. His TAP evaluation is scheduled for June 2026. He had the DOEP course that he completed last month. And the TAP evaluation, if he's transferred here, does the TAP evaluation take place here?
Yeah.
Oh,
yes, Judge, they would transfer it over.
okay.
Judge, if I may, I have the case number out of the 367th District Court in Denton.
Okay.
That is F24-1761-462.
All right, probation, were you able to take that down?
Yes, sir.
All right, so if you can see what his conditions are, and the conditions I'm going to give him now, if they're the same conditions that he has out of that case, just let him only do the conditions for that case. All right, so this is going to run concurrent with F24-1761-462 out of Denton County. And there's going to be field visits 1 time per month for 6 months. Proof of employment within 45 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. And where you live, are there any children in the home?
No.
Okay. There is going to be 100 hours of community service restitution for every sober support meeting completed. An hour will be deducted from the community service restitution. And I'm going to sentence him to 5 years in the prison, suspended and probated for 4 years. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. And do you have a current driver's license?
I do not, Your Honor. I just recently got a Texas state ID, but no driver's license.
All right, probation, I'm so sorry. One of the condition that needs to be added, there is to be no driving until you present a current driver's license and valid driver's license to probation. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you, Judge.
Thank you.
This courtroom session showed us the full spectrum of justice, from second chances denied to structured opportunities for rehabilitation. Veronica Callahan's case reminds us that repeated violations can close the door on leniency, no matter current progress. Meanwhile, other defendants were given structured paths forward, proving that the court doesn't just punish. It also tries to correct behavior when possible. Ultimately, every decision came down to one thing: trust, whether the court believed the defendant would follow the law moving forward. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.